The President, please be seated. I would like to declare the meeting resumed. We will continue from where we left off this morning. There remains a few more items to discuss this afternoon. This morning we left off where the prosecutor requests that additional individuals be heard. And the defense team for Mr. Nguyen Chia also requests to hear evidence of 5 further individuals. And 3 appear on Annex 3, individuals identified as relevant to case 002, but not for case 002/01, namely TCW 644, TCW 689, and TCW 699. The two have either not previously been identified at trial, or maybe individuals who were incompletely identified by Nguyen Chia list, for example. And today, could the Nguyen Chia defense team elaborate on the nature of this request?
Yes, we can, Mr. President. Let me start by apologizing for mentioning this morning the name of the documentary maker. I shouldn't have done that. I should have called him TCW 720. I'm also mentioning TCW 720 because in his film earlier referred to, the film about Tu Po Tray, he is not only portraying the soldiers spoken about by the prosecution, but in that same movie you can also see the documentary maker asking our client Nguyen Chia whether there was in fact a policy existing in and before the DK period of targeting and killing Lon Nol soldiers and officials. And in that same documentary, our client is very adamant and very persuasive, I might add, when he says no such policy existed. And it is this foundation which ultimately lies underneath our request that we filed as a courtesy copy yesterday, our request to summon key witnesses in respect of Tu Po Tray. Now, we haven't asked, Mr. President, 5 witnesses in this request. We've asked 6 witnesses. And I would like to start, if you allow me, with that 6th witness mentioned in this request, TCW 223. TCW 223 is, for the Nguyen Chia defense team, without a shadow of a doubt, the most important witness. Not only because TCW 223 knows Nguyen Chia very well, the reason why we've asked for him to appear as his one and only character witness, also because he was a senior military commander, having knowledge about the existence of a policy, existing yes or no, to target Lon Nol officials and soldiers. He was present, presumably, at a meeting in which this policy was discussed, and he seems to be strong in his earlier, between brackets, evidence that there was no such policy, and that there was no policy in which the targeting of Lon Nol officials was discussed. There was no killing of Lon Nol soldiers and officials. So this fact, this importance of TCW 223 is the underlying rationale of our further request. Let me, Mr. President, take the opportunity that I would hope that today, or maybe in a later stage, we will be informed as to why the Chamber couldn't reach an agreement as to the summoning of TCW 223 as the one and only character witness for Nguyen Chia. That's a separate issue, but we hope to be enlightened on that subject. But having said all this, the reason that we have now asked for 5 additional crime-based witnesses in respect of Tu Po Tray is the fact that in the week of the end April, beginning of May, the only two witnesses testified in respect of the events allegedly occurred at Tu Po Tray. It's obvious that the prosecution and the defense agree on the fact that these 2 witnesses did not confirm at all what they have been testifying in front of the OCIJ. There were huge discrepancies, which we all have described in our request, between, on the one hand, their statements, and on the other hand, their live testimony. Therefore, we find it of the utmost importance that the 5 witnesses that the OCIJ are relying on in their closing order should be summoned and appear as witnesses in front of the Chamber. I've heard the prosecution say today that if it's not possible for whatever reason to have the 3 soldiers in the movie called here as witnesses, then at least 3 of those 5 should appear. So it is for the defense of Nguyen Chia of crucial importance that not only TCW 223 will appear, but also those 5 additional Tu Po Tray witnesses. We have been describing who they are and what they could testify, and what they have said earlier in their statements to the OCIJ. I'd be happy to paraphrase that, but I'd be also happy to refer the Chamber to what we have written in our request for these witnesses. So, to sum up, it's for the defense crucial that we have all 6 witnesses appear before we close the evidence in this segment of the trial.
The President, thank you very much for clarifying this issue. Does any other party object to the calling of these individuals proposed by the defense team for Mr. Nguyen Chia? The President, yes, the prosecutor, you may proceed.
Thank you, Your Honour. I just wanted to reiterate our position today. We don't necessarily object to the calling of witnesses from Tu Po Tray. The prosecution and defence are in agreement that further evidence would be beneficial to both parties to discharge their obligations. All that we say is that the Chamber will have to determine when there is enough evidence, and what we have suggested is that if we call the 3 witnesses in the video and the amount of evidence is satisfactory, it may be the case that we may not need to get to call all of the witnesses that Nguyen Chia's counsel have put forward. But what I would suggest, based on the principle that this court should be dealing with dealing with the best evidence from the video, as discussed, those 3 soldiers appear to provide more direct eyewitness evidence than the 5 that have been put forward. So we would ask that those 3 witnesses be called first, and then subject to the court time, etc., then proceed down the list to call the other witnesses for Tulpo Tray. It's just a question of time management and ensuring that both parties get enough evidence called to be able to discharge their obligations. And with just also to be clear for the record, in relation to TCW 233, the prosecutors confirm their position on this witness, and that position has been laid out in previous motions that we'd filed to the court. They can be found in prosecutors' filing E93/2, dated the 11th of July 2012, and E9/14/1/1/1, dated the 11th of March 2011. And we would also like to put on record that the prosecution has put forward to this court that if the witness is not called to this trial chamber, that their statements be admitted. Certainly TCW 233's transcript be admitted by agreement with the defence, and we will also submit that the transcript, the associated transcript of the interview with Ben Kiernan of TCW 92 also be admitted if, in fact, TCW 233 is unable to come to court. Now, the document I'm referring to is D313/1.2.406.1, and that contains the record of interview of TCW 223 in relation to the incident or the meeting that he states that he was at with Nguyen Chia on the 20th of May 1975, when it was discussed, when it was asked what the position was in relation to the policy of non-Nol soldiers. And the reason why we asked that TCW 92's transcript, which is an associated interview, also be admitted, is that it puts the statement of TCW 233 in perspective as to his version of the events of that meeting on the 20th of May 1975, which is different to that of 233. Again, we would only request that this be done if the defence agreed, because these statements do relate to the acts and conduct of the accused, and perhaps would otherwise not be put before the chamber. But if 233 does not come to court, I think to preserve the record for both defence and prosecution purposes, that the prosecution would agree that those statements be tendered as evidence. At least that would be before your honours and you could take that evidence into account. But that would require the agreement of the Nuon Chea team and the Q Sampan team. Thank you.
The President. There could have been a problem in the translation because it appears that there was a difference in the discussion. Mr. Smith, you raised issue relating to TCW T223 or 233 because there was only one witness proposed by the defense team for Mr. Nuon Chea. Out of 6 of them, there was one witness whose pseudonym is TCW223, not 233. So this is a point of clarification so that parties are not confused by the different pseudonyms of witnesses.
Thank you, Your Honour. My mistake. I was meant to refer to TCW 223.
The President. Thank you. And Counsel, please hold on. The lead co-lawyer for the civil party, you may proceed.
Briefly, President, but it has to be said, the lead co-lawyers have no opposition to the proposal made by the Nuon Chea defence, and we leave the Chamber the freedom to make a decision on whatever eventually is chosen, but we have no position in principle.
Thank you. Counsel Victor Coupe, you may proceed.
Thank you, President. The thing what I would like to stress is the following. We have, as you know, requested earlier for TCW 223, but it's very important that all the parties and the Chamber realize that this is a new request based on the addition of Tulpo Tray to this segment of the trial. We have requested TCW 223 earlier. He has been denied. We have been describing this in our request. Now we are in a new situation because of the adding of Tulpo Tray. We are of the opinion that his testimony is becoming even more important and is in fact crucial for the understanding whether there was in fact an underlying policy of killing or targeting Lono officials when it comes to Tulpo Tray. He is crucial to decide whether the events, if they happened at Tulpo Tray, were local actions of revenge against Lono soldiers, or were in fact the execution of an earlier existing policy. So, just to be absolutely sure, this is a new request with new arguments when it comes to TCW 223. And like I said in the beginning, and I cannot stress this enough, this witness is for our defense of absolutely crucial importance.
Thank you. Counsel Viken, you may proceed.
Merci, Monsieur le Président. Pour ce qui concerne...
Thank you, Mr. President. Regarding the submission of written statements by witnesses who cannot appear concerning the acts and conduct of the accused, we are opposed in all cases, as we pointed out in E277, which contains our conclusions on such matters, which was submitted on the 9th of April 2013. Thank you.
President, thank you. Finally, and in relation to the role of Keo Sampon, and in particular with regards to political education, The co-prosecutors seek to call TCW 164 and TCW 781. Both individuals were identified by the co-prosecutors as key individuals to be heard in case 002/01 at the last TMM, but are currently proposed for deferral to future trials by the trial chamber. Could the co-prosecutors now elaborate on the basis of this request?
Thank you, Mr. President. Again, the basis of this request is founded on the fact that much evidence has been heard in this case now, and as of Your Honour's announcement on the 31st of May about what further witnesses will be called in this trial, and based on our assessment of the evidence that has been admitted by the Chamber through witnesses called and through documents admitted, it was our view that, bearing in mind the position of the Khieu Samphan defence that has become louder and clearer as the trial has continued, that Khieu Samphan had no real authority in the DK regime, that he had no substantive participation in the joint criminal enterprise, in the different policies during the DK regime, and in large part he had no knowledge of the joint criminal enterprise and the crimes occurring during the period. Bearing in mind that position, and also the position in relation to the statements that the prosecution have asked to be put before the Chamber relating to, amongst other things, the acts and conducts of the accused in the DK period, and understanding the trial chamber's position and international practice that statements should not be admitted to this court as evidence, at least where they contain information relating to the acts and conduct on the accused, unless there's cross-examination by the defence. Well, certainly those portions of the statements should not be admitted. That generally is the international practice, and that appears to be the decision of the Chamber. So the numerous references to Khieu Samphan's political indoctrination or participation in promoting the different policies of the JCE, the forced transfer policy, the worksite policy, the killing and targeting of the enemy policies, among others. Much of that evidence has been collected in the statements, won't be before this Chamber. And when we look at what the prosecution originally proposed for the trial chamber to hear in relation to Khieu Samphan's authority, his participation in the joint criminal enterprise, his membership with Nguyen Chia in that joint criminal enterprise, and also his knowledge of the crimes that were occurring at the time, we had proposed 7 witnesses, and now we can see that of those 7, 2 have been heard before the trial chamber, and those 2 have now they're public witnesses, Chia Se and M. Un. And then we have another witness who we discussed this morning, TCCP 186, whose evidence is incomplete, and it relates to this very point, the allegations relating to the political indoctrination of CPK policies by Khieu Samphan. We have heard 2 other witnesses, Peen Keen and Rus Soy, a defence witness, who made reference to these activities of Khieu Samphan. But of the witnesses, the prosecution would have liked to have called to prove this aspect of his role, to prove his strong association and membership to the Joint Criminal Enterprise, particularly with Nguyen Chia, to prove his authority and influence and knowledge of those policies, which is necessary for us to do. Our assessment is that we would like to call 2 more witnesses to have a significant opportunity to prove that aspect of Khieu Samphan's role, particularly as the DK period was for the 3 years and 8 months. We propose that the two witnesses, the time period to question them would be half a day each, so it would be 1 day for the 2 witnesses. We propose to focus on that aspect alone. When we look at the 2 witnesses in terms of their probative value, to demonstrate Khieu Samphan's role in the Joint Criminal Enterprise and his knowledge of the policies and his promoting of the policies. If we look at TCW 164, and you'll see from our submission that we made to the Chamber just before this trial management meeting, that Khieu Samphan, he testifies that Khieu Samphan and Nguyen Chia participated in 2 study sessions at Borikela Stadium in 1976 and 1978, and he states that Khieu Samphan discussed the arrest of Pang from Office 870 because he was a traitor collaborating with the Yun, and he also describes Nguyen Chia at the session in 78 with Khieu Samphan talking about the treason of Khoi Ton. And if we look at what TCW 781 has to offer in this regard, he's a Ministry of Commerce worker who talks about the disappearances of half of his unit over that period for the purpose of study sessions. And he explains the purpose of study sessions was in fact known, that people were being arrested and disappeared and taken away. And then he talks of a meeting with Khieu Samphan, Van Rit and Nguyen Chia in early January 1979, where the 3 of them announced the end of calls for study sessions, meaning ends of call study sessions because of the need to be unified to fight the enemy. And this witness understood that to mean that there would be no more arrests because we need to unite to fight the Vietnamese. So, Your Honour.
President Council, you may proceed.
Yes, Mr. President, I would like to interrupt my learned friend because I don't know what is happening now. We are now discussing technical matters and the prosecutor is pleading. He goes into details. He talks about testimonies and what is said. I don't see the relevance of this. We are in a trial management meeting and the prosecutor is going a bit too far.
Your Honour, I understand my friend's point. I mean, it's obviously relevant. It relates to the reason why we'd like to call these witnesses. But certainly we would request that we call, that the Chamber call these 2 witnesses because it's strongly disputed by the Khieu Samphan defence team that he was involved in these political indoctrination sessions where he clearly shows his knowledge of the joint criminal policies. And as we've only had 2 witnesses called by the prosecution on that point to discharge our burden, we'd like to have a reasonable opportunity to do that. by asking for 2 witnesses over a 1-day period. Thank you.
Thank you. Other parties, would you like to make any comment regarding the request by the prosecutors to hear these witnesses?
Yes, Mr. President. We endorse the application made by the co-prosecutors, and in that vein, we have also made a request that TCCP 214 be heard for similar reasons. Would you like me to explain very quickly what these reasons are that would allow the defense to respond to all these proposals? Or would you like me to do that later? We made this application before the Chamber officially a few days ago, and it's TCCP 94. I wouldn't want to state what I said orally, what was already written. These arguments are identical to those elaborated upon by the co-prosecutors. This person is on our initial list. At one point, that person was on the Chamber's list. That person was proposed with regard to the structures as well as the role of the accused. That person is also in a position to provide information regarding speeches delivered by Mr. Kyo Sampan to Cambodians from abroad, particularly in May 1976. And in particular, that person is in a position to talk about other speeches by Mr. Kyo Sampan. He will also talk about Mr. Kyo Sampan's knowledge of policies of democratic Kampuchea. I'm going very quickly, and I'm relying on the contents of my application. I believe that that person could provide interesting and relevant evidence. That person is a civil party, of course.
President, Councillor Vikand, you may proceed.
Thank you, Mr. President. I would like to respond to the prosecutor. I am somewhat amused to hear the co-prosecutor give the impression that all of a sudden they are discovering the existence of a rule in international criminal law according to which witnesses testifying to the acts and conduct of the accused should be challenged in cross-examination. And similarly, when I hear the co-prosecutor say that in the course of this trial he has discovered that Mr. Kyo Sampan challenged the facts against him, I would like to refer you, Mr. Co-prosecutor, to the opening statements to this trial to remind you that the position of Mr. Kyo Sampan has not been formed in the course of the proceedings. It has been very clear since the very outset. I think we have heard arguments and submissions that were given in bad faith. The Chamber will rule on that. The co-prosecutor, in addition, has cited all the witnesses who have testified on this issue, and there are quite a few. And we are opposed to the calling of additional witnesses. I will not elaborate any further, Mr. President. We are running out of time, and if those persons are not called, we will proceed quickly to the closing arguments. Regarding the civil party, let me say that there again, the council or the civil party lead co-lawyers has said we made a request some days ago. That request has already been the subject of a lengthy debate at the hearing of the 11th of January 2013. It is E1/251, and it is TCCP 1994. Let me respond. The table disclosed by your chamber after the issue of your memorandum of the 30th of May was very clear as regards the situation, your position on that application, and we are therefore opposed to the calling of that additional civil party.
President, thank you. And Nunchia's defense, do you have any comments to make regarding the request to hear additional testimony of true witnesses by the prosecution and a request by the elite co-lawyer for hearing a civil party that is TCCP 94?
No, Mr. President, we don't have any submissions.
Thank you. Finally, it appears that the Kyosampan defense does not seek to call additional witnesses at trial. Can the Kyosampan defense confirm that this is the case?
A priori.
In principle, at this stage of the discussions, no, Mr. President. If the situation were to change as regards the witnesses who may be called after the numerous applications that have been made, I would reserve my right to respond later on, and I will not therefore respond immediately. Completely independently of this response, let me point out to the Chamber that on the table that you issued and which contains all motions filed during the proceedings, there is one motion missing on that list. That is a Kyosampan motion, and the exhibit number is E220. And in that motion, which was filed on the 14th of August 2012, titled Application by Mr. Kyosampan to tender into evidence a new document. That document is missing on that list. That is all I wanted to say, Mr. President. That motion by the defense of Mr. Kyosampan has not been addressed by the Chamber, decided by the Chamber.
President, thank you, Councillor Weekend, for this very important piece of information. We will review all the requests as we receive many requests by all the parties. That is in regards to the proceedings in 002/01, and the total number is 285. And I think there could be a mistake in missing out that request by your team. We will review and resolve this matter in due course. And thank you for raising this matter to the Chamber, Councillor Weekend. The Chamber thanks the parties for their submissions. The Chamber will consider them and will shortly indicate which of these additional individuals now sought will be called at trial. Justifications for why any are not heard will be included in the Chamber's final witness decision, which is currently pending before the Chamber and which is expected to be issued over the coming weeks. And before we conclude the trial management meetings, are there any remaining matters that the parties wish to raise? And as in the case of Councillor Witkan, he raised a matter regarding the missing request by Khieu Sampon, that is document E through 20. That he did not find it in the annex of the request submitted to the chamber by all the parties. And that is a useful piece of information for the chamber, and we will review it in due course. If there is no matters to be raised by the parties, this concludes the trial management meeting, and the chamber thanks the parties for their input and will issue its scheduling order for next week's document hearing very shortly, as well as for the last remaining hearings in case 002/01 in due course. And on behalf of the trial chamber, I would like to thank the prosecutors, the lead co-defense teams, and the lead co-lawyers for civil parties, as well as all the concerned staff for your support in this trial management meeting. And which facilitates the smooth operation of the trial management meeting, and I wish you all the very best. And success in your respective duty. I declare the closure of the trial management meeting now.